Tonight I have two gentlemen joining me on the program. Atiku is a constitutional lawyer and he's right here with me in the studio, while Libra Sashoma, who is also a lawyer and a political affairs analyst, joins us via Zoom. Gentlemen, thank you so much for joining us on Politics Tonight.
Thanks for inviting us.
Right, so another time, Mr. Libras, welcome to Politics Tonight.
My pleasure. Thank you. Thank you
for
the opportunity.
All right. So another night to look at the Supreme Court's judgments, the 7 issues that have been raised, questions seeking answers, the lessons and the key takeaways from that judgment. So let's start this way. This legal battle over the 2023 presidential election is finally over. What's your view about that intense electoral dispute?
I think that as intense as that legal dispute was, it was merely a ritual.
A ritual?
It was a ritual. I think that politicians have not yet learned fully the need to assess their situation after an election, weigh their options, and tell goading lawyers. I didn't use the word gold digging, goading those who are goading them and instigating them, that they should get behind them and that they are not going to go to court to challenge the results or the outcome of the election. And that's why I call it a ritual. After every election, Nigerian politicians, will throng the courts, the tribunals, to say that they've been robbed. And indeed, some of them could have been robbed. Some of them will get their mandate restored, but many of them will be damned. And so, all things being considered, this presidential election petition shouldn't have been embarked upon. And that's what the Presidential Election Petition Tribunal and the Supreme Court roundly stated. At the Court of Appeal, acting as the tribunal, it was a unanimous decision. And at the Supreme Court yesterday, it was also a unanimous decision. So if you compare the determination with the previous ones, there was a testy one, the Yaradua one in 2007, where we had a split decision, 3-4. It was tough. 3-4 at the Supreme Court. So with that petition, you could see that the Supreme Court delved into the matter and felt that the election was hopelessly manipulated and rigged. But this one was, in the circumstances, fairly conducted. All the issues that were being raised were just being raised by partisans, just because of the ritual I've talked about. It appears to me that some politicians want to weigh their continued relevance after an election with going to court, not by going to, with going to court, so that they will continue to be in the news and then they will continue to hoist aloft the hope of their supporters, instead of taking responsibility, telling their supporters that we contested this election, we've lost, and so next time will be better. The battle to reorder Nigeria to make it better is a lifelong battle. So it's not going to be a 100 meters dash. It's going to be say all those lofty things and then move on. They think that they were to do that, that would mean that they've just disappointed their... Whereas it's not all about being hailed to go on. It's also about looking at the electorate and say, this is where we are, and this is what we need to do to get a better society. So we can go into all the issues that were raised, and the Supreme Court has confirmed in its decision now that many of those issues that were celebrated in the polity as very contentious issues were, as a matter of fact, afterthoughts They weren't part of the original complaints. And so they were now raised after that, and they were now over-celebrated as the pillars of salvation for those who were raising those issues in the politics. And I think that we could debate them one after the other, but that's my general impression.
Mr. Ogunye, before we get to the issues, because these issues are issues we need to really look at and understand very well. Mr. Libros, I mean, while you react to these judgments, do you agree that this is clearly a waste of time and indeed an abuse of court processes? Are you there, Mr. Libros?
I would toe the line of my... Yes, I can hear you. Can you hear me?
Please go ahead.
Yeah. Okay. I said I would toe the line of my senior and Egbon GT Ogunye in the studio, and I would say, if you look at the provisions of the Electoral Act, the provisions of the Constitution, vis-a-vis the provisions of the Evidence Act, also talking about irregularities in an election. Yeah, we had irregularities in an election, but if you look at the provisions of the Evidence Act, for example, once INEC declares a result, by the provisions of the law, that result is deemed regular. It is the man who is disputing the irregularity. The onus is now on him to prove such irregularity. And we all know it's elementary for every election petition practitioner that proof of irregularity is usually unit by unit. I mean, polling unit by polling unit, which is usually a very tall order. And the materials for proving this irregularity are with INEC that conducted the election. I will give you an example. And then secondly, by the provisions of the new Electoral Act, you cannot amend an election petition once it is filed, except on reasonable circumstances. In most cases, these circumstances are not, the reasonable circumstances depend on the mind. Let me just say, you can't amend. So let's leave it at that. And I will, in buttressing that point, I will give you an example for which my Bonjiti Oguye is also aware of. There was a petition at the Election Petition Tribunal in Imo State, and I applied to amend that petition at the tribunal while the tribunal was still sitting. In fact, the tribunal judge made me look like a lawyer who does not know his onion. But because the client, before I came into the matter, the deposition that had been filed was wrongly filed. And the tribunal said we had to swim and sink with that deposition that had been filed. That is not technicality, because that is the provision of the law in as far as electoral jurisprudence in Nigeria is concerned. But if it's a civil matter, you can simply bring an application to amend. So I'm laying this foundation to answer your question. Against this backdrop, you know that now you have, by the provisions of the Constitution, you have 180 days within which to prove this irregularity. In some cases, take for example, you have a senatorial matter, a 6 local government, and the court, the tribunal says 39 witnesses are not enough to prove irregularity in a senatorial zone where you have about 100 and something polling units. And then you now have the entire country, and you think that 27 witnesses would be enough to prove irregularity in the entire country. So when you put all of these together, when you piece them together, the answer you will get is that sometimes this tribunal, this petition are really unnecessary. But because politicians will want to remain relevant, and in most cases, some of the supporters would think they have been compromised. That is why they did not go to court. That is why they didn't challenge the outcome. So they know, even the lawyers that are filing the petition also in most cases do not even believe in the petition. But because of what comes out of it, they file and then get to court. Because also we do not take responsibilities for our action here, we look for who to blame. We say, blame the judiciary. That does not mean that INEC does not have a blame in all of this.
So, Mr. Libros, what aspects of that judgment do you consider as most instructive? And what key lessons do you think can be picked from the judgment?
It is, a lot of people have been saying, even the layman had said, Justice Okoro's statement that election petition are not only sui generis, the rules are like the rock of Gibraltar that cannot be moved. So this afterthought of going to fish for evidence after you have filed your petition, and then midway, you now go to fish for evidence, even evidence you know you cannot bring in at the court of first instance, you now go to Supreme Court and say the Supreme Court.
Mr. Libros, are you there? Okay. All right. Let me continue with Mr. Jitiogwe in the studio. Right. So help me understand this. And for the purpose of people who do not, have a legal background, when the justices say that a subpoena is not a tool to circumvent the provisions of the law, what does that mean?
Okay. You recall that at the tribunal, many out of about 13 witnesses, almost 10 witnesses of Mr. Peter Obi, the presidential candidate of Labour Party. And their depositions had been thrown away. They were thrown out. Now, some of those depositions and some of those witnesses were subpoenaed witnesses. And I will break it down. You know, from the date of declaration of result, a candidate who participated in the election who is saying that the results wasn't acceptable, wanted to go to the tribunal, has 21 days to go to the tribunal. I reference section 132, subsection 7 of the Electoral Act. He has 21 days to do so. Now, but because of the sheer volume of amassing evidence all over the country in the presidential election, in which the entire country is the constituency, you know, so lawyers will do their best, and in that case, this being charitable now, Mr. Obi's lawyers did their best to quickly amass the evidence they had, and then they filed their petition. But realizing that what they filed was not sufficient in terms of the witnesses they could bring within that 21 days, they then got the tribunal to issue subpoena on them. A subpoena is summons to a prospective witness to come to court, based on the order of the court, to come and give evidence. Usually, those witnesses so summoned are called court witnesses, because it's like the court summoning them. And so they got the tribunal to issue subpoenas on witnesses that they would have brought without subpoenas if they had all the time in the world and they could put all their things together. Okay. The tribunal granted those subpoenas. So they brought in those witnesses with their depositions. At the stage of giving judgment, based on the argument, the tribunal held that what they were trying to do was to circumvent the 21-day deadline, that they were being clever by half, that the witnesses they got the tribunal to subpoena were witnesses that were always available to them. They are party members, they are experts, and not witnesses of, say, INEC or some other witnesses that they didn't have control over, and that therefore those depositions were rejected. And that's what the Supreme Court was also echoing, that, look, you cannot circumvent that rigid provision of 21 days by then getting the court to issue subpoenas, only for the court to then realize, indeed, it's an abuse of court process. The court would then realize later that you took us for granted. You asked us to issue subpoenas. We didn't quite know at that stage that you wanted to bring in witnesses that were your own witnesses that ought not to have been subpoenaed in the first instance. And therefore, you know, what you did was wrong. And then Ranley.
So what lessons are there for lawyers and the politicians?
You know, there are two lessons here. Legal processes are technical. They require a certain degree of expertise and familiarity with that aspect or branch of the law or legal practice, right? And so it may well be the case that whereas the law expects that everything be done in a jiffy, 21 days, and the time for determining the petition is 180 days, and then 60 days at the appellate level, because of the mischief of an elongated election petition determination, as we had in Anambra State, for instance, when Mr. Peter Obi almost couldn't recover his mandate for about 3 years when Dr. Chris Ngige was there, which was the mischief that the law was trying to cure, whereas that's the expectation of the law. It may well be that we have to look at those provisions again to really, really find out whether this thing could be done, particularly in the presidential election, within 21 days. That's one of the takeaway. The second is that lawyers who want to take this, who are being well paid, you know, lodge in a hotel at the capital city in Abuja and all that, know that they have 21 days to put everything together. And that once they are not able to do that, it will be honorable professionally for them to even say, this petition we brought falls short. We are withdrawing the petition. We are going home. Okay? Because inevitably, grief will await such a petition, you know, if they want to bring in certain things.
All right.
And then thirdly,
thank you very much. That was very fundamental. So let me come to Mr. Libros. I mean, one key reality of the appeal was Atiku's efforts to bring fresh evidence in his appeal, which the Supreme Court rejected. Did you see that coming? All right. I guess Mr. Libros is not there anymore.
Yes. You know, so the issue is that is also what the Supreme Court did justice according to law, according to procedure, according to the provisions of the Constitution, according to precedents. Certain persons in the polity were expecting the Supreme Court to do justice according to their whims and caprices and their unreasonable expectation and fertile imagination, if I would say. But that's not how the law works. So it was predictable that the Supreme Court was going to rule and decide the matter in the way the matter was decided. The Atiku CSU escapade, for example, was an afterthought. That was not part of his petition. And that was what the Supreme Court was saying, that even if you had brought those depositions from Chicago after the 21 days, after you had filed your petition, the lower court wouldn't have had the jurisdiction, the power to entertain it, because that would be outside the 21 days. And therefore, if the lower court wouldn't have had that jurisdiction, how could the Supreme Court then have the jurisdiction to entertain it? So it was clear. They weren't saying something that was too profound, given what they've been saying before at the Supreme Court. And every lawyer will understand what this was all about. And that was why, even when the 25% thing was being raised, which the Supreme Court also dismissed, the wave of the hand, it was clear, in spite of the fact that some of the lawyers that were raising it were senior lawyers in the polity. It was hair-splitting and irrational that if somebody didn't have 25% in Abuja, and they were saying all these things, and they were, you know, moving, and then a lot of people in the polity were saying that, driven, of course, by the social media, but that was arrant nonsense. And if you try to caution at that stage, say you are not the court. That's your opinion. Your opinion may be so enlightened, but that's your opinion. Let the court decide. And when the court decided, what did the court do? at the level of the Court of Appeal, the justices came very hard on those who were mouthing that silly idea of 25%. And that's why some people said, their justices were very angry at the level of the Court of Appeal, because one of their justices said pointedly that it's regrettable that those who were orchestrating this suggestion of 25% were very senior lawyers in the polity. Okay? So the Supreme Court decided what every lawyer of average knowledge of proceedings and electoral jurisprudence, will know about how the Supreme Court would decide it. So it wasn't strange that the Supreme Court decided.
So, Mr. Libros, let me come to you. The Supreme Court upheld the decision of the appeal court that the IREF cannot be used as collation center for election results. Why did you think the petitioners and their lawyers failed to do the needful?
Can you hear me? My network is
I can. Please go ahead.
I don't know why. Can you hear me?
Please go ahead. I can hear you. Mr. Libros, can you hear me?
I have. If you read the judgment of Oyetola and Madeleke, yes, I can hear you. I can hear you.
All right, please go ahead.
So, like I said if you read the judgment, okay. I said if you read the judgment of Oyetola and Madeleke, the Supreme Court in that judgment had made that same pronouncement that though INEC has the powers to create guidelines, that the Supreme Court instructively in that judgment said, IREF, that it's a viewing portal and not a collation portal. And if you look at Rule 93 of the Supreme Court guideline, it states categorically that the collation shall be by manual process, and that where the hard copies of the results are not available, that they shall resort to copies from IREF, generated from IREF, and that where the hard copies and the IREF copies are not available, that they shall now resort to the copies handed over to the police. That is Regulation 93 of INEC regulation. So everything that the Supreme Court said yesterday, they have said consistently that they said yesterday that they had not said before. That is why, for me, election is conducted and won on the field, because I consistently maintain that the rule states categorically that once results are declared and announced by INEC, they are presumed regular. The presumption of correctness is in favor of INEC. Until that rule is changed, all of this having to prove irregularity in 773 local governments across the federation within 180 days, 21 days within to 5, and then you have a limited time to call witnesses. It's a practical impossibility. It's not about, the court being compromised. I just gave you an instance of a deposition that was wrongly filed. And then I prayed the court for amendment, even though I knew the rules. And the court said, well, when were you called to the bar? And I felt like I didn't even know law, because I knew what I was doing, and the court just simply followed the rules. It is also Nigerians that insisted, because of the time it took. Peter Obi's case took about 3 years. That's at the election tribunal in Anambra. The case in Edo took about the same time. The one in Oshu took, Gitogu also can remember, it took about 2 years plus. Ekiti, the same thing. That is why these states have staggered elections. So because of all of those mischief, the lawmakers and Nigerians insisted that the time for proving irregularities in the election should be abridged to 180 days. So if you have 180 days to prove irregularity in a State House of Assembly matter, should you also have 180 days to prove irregularity in a presidential election matter? Is that possible? So I've consistently told people that, look, this idea of, oh, IREM, the court said they were going to transmit results. When INEC told you that they were going to transmit results real-time online, and they included section paragraph 93 in their rules, some of us raised, pointed people to paragraph 93. They said, no, INEC had said it and it should be taken as the gospel truth. So these are the challenges, and until we sit down, the politicians truly, the people, not the politicians now, the politicians understand the rule, but they're just playing a mind game with the people. Until the people take their time to truly understand the rules of the game, and then insulate and divorce themselves from the sentiment and emotion, politicians and lawyers will stop taking them for a ride. But if they continue in this trajectory of always believing hook, line, and sinker, what every politician is saying, then there's going to be a problem. I quickly round up. The PDP had opportunity to put their house in order, for example, going into the election. But selfishness and self-centeredness would not allow them. But after the election, you saw Atiku Abubakar now calling on Kwankwaso and Peter Obi to join hands with him. He had that opportunity to ask them to join hands with him before the election, and all of this wouldn't have happened.